You notice that Stephen Slisher, even though the judge had previously ordered, did slip into referring in the closing Derek Chauvin as the defendant. And I think it's something that we all do. We're so used to prosecutor and defendant, although in his courtroom he didn't want George Floyd being referred to as the victim, or in the trial Derek Chauvin as the defendant. But tell me, Stephen Slisher, did he make it seem real that this was anxiety, that this was a problem that Derek Chauvin had trained for and was supposed to deal with instead, and when he came upon the scene, instead, he just threw that training out the window?
Linda, I think Slisher did a good job, and you compare and contrast him to Blackwell, and I like what the state did. They put Slisher on first for the opening argument. He's a little more dry, a little bit more methodical in terms of how he discusses the evidence. Blackwell more animated, so he kept some of those good rebuttal arguments in his back pocket there. But I thought Slisher did a good job addressing the anxiety, and really kind of the key testimony that you and I have talked about for weeks is when George Floyd was removed from the vehicle, he said, thank you. He was happy to be removed. He was compliant at that point. At least that's the argument that Slisher made. And therefore, the restraint and putting him in the prone position was entirely unnecessary. I like what Slisher did, and he went through frame by frame and discussed that evidence in great detail.
And Neama, when he first went to that and did the two thank yous, thank you, and mentioned them, I thought one was for you and of George Floyd, and that he had it in his phone, he called her mama in the phone, mama, to try to lessen the impact of when he was dying, that he was saying mama, because we were all like crying. He's reaching out for his mother. Number one, was this an effective rebuttal? And number two, does it even matter?
I don't think it was very effective. I think Nelson did a good job with the hand that he was dealt, but some of those arguments were a stretch, and that was one of them. Whether he was calling for his mother or his girlfriend, Ross, I don't think it really makes a whole lot of difference in the charges in this case, the second, third-degree murder and the second-degree manslaughter. So don't really like what Nelson did with his cross-examination of Ross there, and I thought Palomas was an outstanding spark of life witness. Love the testimony about George and his mother. I really also like him talking about George Floyd being a church-going man and his relationship with his basketball teammates, him playing football. I think he was fantastic and an outstanding spark of life witness for the state.
And Judge Brandon Birmingham from Dallas, Texas, I know you were laughing because sentencing guidelines, which initially were not guidelines, they were like the judge must sentence here if this falls, and now they are sort of guidelines and all. That was the issue in the criminal law: fairness, justice, fairness, equality. Is it still the issue where you're practicing in California and in the federal courts?
Absolutely, Linda. And pre-Booker, those sentencing guidelines were mandatory. That was a seminal Supreme Court decision. But one of the primary reasons the sentencing guidelines even came into existence were to avoid what we call unwarranted sentencing disparities. And Judge Birmingham hit it on the head. County to county, even state versus federal. I mean, narcotics are the best example. You can get significant time in federal prison and have to serve most or all of that time, about 85%. Whereas if that same case were prosecuted stateside, you're looking at a much, much less sentence.
And Neama, I have to cut you off because you know what I have to take? I have to take one of those. Wait, hold on a second. Hold on. Breaking news, a verdict has been reached. A verdict has been reached. I'm sorry, Neama, and I'm sorry, Judge, to cut you off. Let me just see where I'm going. I think I'm going to stay with you right now. We will do a little bit of a talk here. Judge Birmingham, I just got off of Brian Buckmeyer. I said I would see him tomorrow because I was surprised that the jury could go through 14 pages of a verdict sheet. Actually, initially, when we asked for your decision on the verdict, before the case, any evidence got in, you had a decision. What was that? Are you feeling comfortable with it? And are you surprised we have a verdict?
Linda, this is great news for the prosecution. This has to signal guilty verdicts, hopefully on the second, third degree, and second degree manslaughter charges. The longer this case goes on, the concern for the state becomes those one or two holdout jurors. I think the state has proven its case, and the fact that we have a result, a verdict in less than 24 hours, bodes very well for the state in this case. I'm expecting guilty verdicts across the board.
And let me tell our viewers, more breaking news. The verdict will be read at 5 p.m. Eastern Time. 5 p.m. Eastern Time, 4 p.m. Central Time. Maybe the jury heard that they wanted to go home. I don't know. But this is breaking news. We have a verdict in the Derek Chauvin case. The parties will, I believe, assemble in the courtroom for a verdict. And it will be read at 5 p.m. Jury takes less in terms of days because, as this jury did, they could take their own lunch hour. They could have lunch brought in. We don't know where they were deliberating because of COVID restrictions and all. But that a sequestered jury does take less time. Why is that? And does that mean their verdict is any less reliable, no matter what it may be?
Linda, they take less time because they don't have to adhere to those standard court hours, right? Here in California, you basically get 3 hours in the morning, another 3 hours in the afternoon, but they can go much, much longer. They can work through lunch. They can work through dinner. They don't have to take that hour-and-a-half break, at least what we have to deal with here in California. And let's just be honest, there's a lot more pressure on them to return a verdict to get back to their life and their loved ones. So no question that sequestering juries tends to move the process along much faster and get a verdict much faster than you otherwise would if the jury is not sequestered.
And Judge Birmingham, if you can call it that, and I think a lot of people would, they could decide that what Derek Chauvin did was totally horrible, dehumanizing, awful, but that it doesn't fit in with all of these elements, and I have them here, that Stephen Slisher, the prosecutor, put up on the board for instance, murder in the second degree or murder in the third degree. Do you think that's a real possibility, or am I just raising, issues that shouldn't be raised?
It's possible, Linda, but unlikely. When we're talking about a compromised verdict here, I don't think an acquittal is a possibility at all here, given the overwhelming state of the evidence and the significant pressure on these jurors to return a guilty verdict. I don't think the defense is going to get 12 out of 12. We talked about the possibility of some holdout, a hung jury, and a mistrial. The best the defense can hope for right now, as we speak, is some sort of compromise verdict where it's a not guilty on second degree and guilty on third degree and second degree manslaughter. Again, I don't think that's likely. I think what we are going to get is guilty verdicts across the board, but that's the best case scenario for the defense here right now.
And when we come back, I will discuss with both of you the fall on George Floyd's left neck. He did it on purpose. He violated the use of force guidelines. He violated the crisis guidelines. He violated his duty to render aid. He killed George Floyd. Tell me, Neama, does this satisfy the felony murder requirement that he is required to satisfy as the state of Minnesota representative?
Yes, he did, Linda. I love what Stephen Slisher did. And actually, let's back up a little bit. I love how Attorney General Ellison charged this case. We spent so much time talking about the third-degree murder charge in this case that went up on appeal and came back. But the second-degree murder, the fact that it was charged as a felony murder and the underlying felony in Minnesota, that third-degree assault, all the state had to prove was just the intent to commit an assault causing substantial bodily harm, not intent to commit murder or anything of that sort. And Stephen Slisher did a great job, and Blackwell did a good job in opening as well, talking about how this wasn't an accident, this wasn't a trip or a slip and fall, this was intentional, and it was a continued assault because Derek Chauvin had many, many opportunities to relieve that pressure over that 9 minutes and 29 seconds, and yet he refused to do so.
And Judge Brandon Birmingham, I have been talking about this.
Was powerful, and that's the primary basis for the cross-examination of Dr. Fowler, the defense expert. And Fowler even admitted, as a physician, Derek Chauvin should have rendered aid when George Floyd stopped breathing. So I think that was very powerful evidence, something that the jury really focused on, no question, and strong basis for both the second degree and the third degree murder charges.
And Judge Birmingham, we only have about
set up an appellate issue right now. So that's really the best that the defense has. From the beginning of this case, Nelson tried to get the case moved out of Minneapolis, the change of venue motion. Now he's trying to say that the jurors are tainted by statements of Congresswoman Maxine Waters and others. Again, that's really the best the defense has here. They're just trying to create a record on appeal. That's it. I think Judge Cahill did a good job of shutting this down and creating his own record that there's nowhere in this country that hasn't heard about the Derek Chauvin murder of George Floyd.
And even internationally. So let me bring Judge Birmingham into this. Judge, I'm ready for you because I know that you are a student of history. There was a case in California where Neama is from called California versus
important trial. I was telling some of my colleagues today of their lifetime. So it's impossible not to have an opinion on this. This touches on race issues, law enforcement, criminal justice issues. So unless you've been living under a rock, and none of these jurors have, it's impossible for them not to have seen this video. Only one of them hadn't seen that video, and he had seen just some still pictures. So it's impossible to keep all that out of the courtroom. But I think, and I agree with you, and I agree with Judge Birmingham, that Judge Cahill has done a very good job of telling the jurors not to read any of the press articles, anything on social media. But for the rest of the public, again, this is part of our everyday lives, and it should be.
Well, you know, we just spoke to Brian Buckmeyer, Judge and Neama, our own Brian Buckmeyer, who's on the ground. We didn't think we'd going to be seeing him so quickly. As a matter of fact, he and I, before our last break, and we're not taking any more, I'm going to tell our viewers right now that we have a pit in our stomach, as if this was our own case, maybe because we've been following it. But there's something more here, and it may have to do with the video. Could you expound a little bit on that?
Yeah, Linda, you and I were talking during the break that, you know, this is one of the most important trials in our lifetime, certainly in this century, because it's not about two men, George Floyd and Derek Chauvin. Obviously, the trial is about them, but this is about our system of criminal justice. And the video and those bystanders, men, women, black, white, young, old, every single person who saw that video knew what Derek Chauvin was doing was wrong. They begged, they pleaded, they implored with him to stop, but he chose not to do so. So that reaction, Memorial Day 2020 on May 25th, where we all saw that video for the first time, I will never forget, nor will I ever forget the moment when this verdict is read on the Law and Crime Network. I mean, it's just something that is going to be one of those key defining moments in our lifetime.
Yeah, and you know, I am, for our viewers, I see that there's...
And it was surprising because it's not something that Nelson raised during opening statement. He talked about the tumor, he talked about the arteries, he talked about the enlarged heart, but he didn't talk about the carbon monoxide poisoning argument. That's something that first came up with Dr. Fowler. And prosecution did many things right in this case, but one of the things they did wrong was not turning over that report. And then Judge Cahill made it clear that if they discussed the contents of that report, he would declare a mistrial. But what the prosecution did do right, and this is that chess game that we always talk about, and that rock star witness, Dr. Tobin, was able to talk about the report that they did have, the oxygen level report, that 98%. So he was able to make the same argument by analogy, saying the oxygen level was 98%. That means at most it would have been 2% carbon dioxide. So they were able to overcome it. I understand what the defense did, what they did. They had to do it. But I love what Dr. Tobin did to rebut that. And I think that's one of the reasons they're going to get a guilty verdict in this case, because of that witness.
And Neama, I'd like you and Judge Brandon Birmingham to watch with me now some of the rebuttal argument of
Johnny Cochran-esque, no question. From the jump, the prosecution told a great story. They told a story about Chauvin's pride and ego that caused him not to relent, not to let up, not to relieve or adjust the pressure on George Floyd's neck. And from the beginning, I love Blackwell's analogy from opening. Let's not forget, believe your eyes. This is homicide. And the quote he used in closing, that there is no excuse for police abuse. Absolutely love both of those. And the way he ended, I certainly will not forget the discussion of George Floyd's large heart, but really this is a case about Derek Chauvin's small heart, and that's the reason George Floyd's dead. Absolutely love that. Highly effective rebuttal. And I know defense attorneys don't like it when prosecutors sandbag, but clearly they had that demonstrative ready to go, and they had some of their best arguments, some of their best analogies, some of their best sayings ready for rebuttal, and they really struck those points home with the jury. Respect Eric. He did his absolute best with the hand that he was dealt, but this was a very tough case. And he tried to focus on the drugs. He tried to focus on Derek Chauvin's perspective or perception, the limited information he had about an unruly suspect who was large, who two rookie police officers were unable to subdue and handcuff. But unfortunately, I don't think it was enough for this jury. I don't think he was able to provide enough arguments, like you said, because that's really what you do. You want to empower your jurors to go in that deliberation room and to fight for you. And I don't think he was able to do enough with the evidence in this case to get those one or two holdout jurors that he needed. But we'll see very soon. For the state, and it's bad for those other officers laying Tao and Kyung, because they're charged with the aiding and abetting the second-degree manslaughter. So even if you get down to that bottom count, that second-degree manslaughter, that's sufficient for the state to go after those officers, and believe me, they will. Now, obviously, in the unlikely event that there's a not guilty verdict, I don't believe the prosecution of those 3 other officers can continue based on that aiding and abetting alone, which is insufficient if there is a not guilty verdict in the Derek Chauvin case.
Yeah. And we're seeing the seal, that courtroom, as soon as the judge goes in there, we'll go to it, and we're seeing also the view outside the courthouse as indeed the crowds are growing. Neama, let me ask you this, though. All right, so you have the other officers. Are you surprised that no deal was made with them to bring them in to discuss maybe conversations that occurred or what they were told? Or is it just that they couldn't give information, or is this too high-profile case involving that 9-minute and 29-second video that you just didn't want to offer them a deal?
No, you hit the nail on the head. There's 2 reasons why they didn't receive any type of deal. First, the evidence speaks for itself. The state and the prosecution, they had that body cam footage. They had the bystander video. They didn't need the officers to testify. They weren't going to add anything in terms of evidence. And the other, there's just way too much political pressure to cut a deal in this case. Let's not forget, Derek Chauvin was willing to plead to a manslaughter deal, and Attorney General Bill Barr rejected that deal. One of the things that folks have forgotten about and they haven't really talked about, but Chauvin was willing to take a deal and serve up to 10 years. But even the Attorney General of the United States thought that it was politically inappropriate to offer that type of deal. And the reason the Attorney General was involved, let's not forget, part of Chauvin's deal would be that he served time in federal prison and that he not be charged with federal civil rights violations. So the Attorney General had to sign off. University of Harvard, and if you're a current student there, definitely take Linda's class. With respect to a not guilty verdict, unfortunately, law enforcement was woefully unprepared last summer for the protests or the riots, depending on what side of the spectrum you're on. I think this time around, law enforcement, there's going to be a lot of pressure on them to not allow the property damage, the injuries that happened in the summer of 2020 to happen again. So they're going to do everything necessary to prepare themselves this time to atone for the mistakes of last summer. With respect to a potential not guilty verdict, obviously as lawyers and Judge Birmingham as a judge, we are all big believers in our system of justice. I disagree with Representative Maxine Waters. I encourage everyone to respect the jury's decision. They were in the courtroom every single day, listening to the evidence, listening to the witnesses. Our criminal system of justice works. I know people were upset about Rodney King. That was a long time ago. That was close by here in California in Simi Valley, but that was almost an all-white jury. And let's not forget, even in that case, those officers were retried, and 2 of the 4 were convicted in the subsequent federal case. So our system of justice works, folks. Believe in it. It's the best system that we have and much better than we have in other countries.
And we could see that here. We could see a federal prosecution judge. And I say that because when the medical examiner,
they're not robots. They aren't immune to these types of societal pressures. Everyone is on social media. Everyone is talking about Daunte Wright, how this could possibly happen where an officer can discharge a firearm instead of a taser, and how this has happened twice before in other states. And unfortunately, in the case of the 13-year-old who was shot after maybe allegedly discarding a firearm, and there was at least some time allegedly after that firearm was no longer in his hand and he was shot. Very tragic case involving a child. So it's impossible for jurors not to be affected by other police killings like these.
Okay, so Judge, if this happens
in jurisdictions that don't mandate body-worn cameras for police officers, and I know we've talked about it a lot, but frankly, if it wasn't for the video evidence in this case, both the officer videos and the bystander videos, I'm not even sure that we would be looking at second-degree murder charges in this case. That's how powerful and important that evidence is, and it's critical to hold police officers accountable for any misconduct.
Neama, let me ask you the follow-up to that. Would we be looking at any charges if we did not have the bystanders' videos, especially the one from the minor child who recorded this, the 9-minute and 29-second video?
We may not, Linda. We may not have any charges, and we certainly wouldn't have murder charges in this case. It may have just been manslaughter or nothing at all. That's how critical this evidence was.
And Judge, all right, so
business, but for me, this trial was personal. Maybe because I've spent so much time with you, Linda, over the past several months now, discussing this trial, covering this trial, everything from jury selection to the guilty verdict that was read today. But you know, our criminal system works. Our jury system works, you know, and I tip my hat to Keith Ellison, the first Muslim American to serve in Congress, now the Minnesota Attorney General, for bringing this case, bringing these charges. We know how difficult it is to charge officers with murder in this country. We know how difficult it is for juries to return guilty verdicts on those murder counts, and he was able to accomplish what a lot of others haven't done. I commend this jury of half white men and women, half African Americans and people of color, for doing the right thing, for making the hard decision. And I commend the public for being patient over the past several weeks as the jury did their job, and they did a fine job. So, you know, my parents were immigrants to this country, and when I talk to my children today as they return to elementary school, we can close this really dark chapter in America's history. This happened at the beginning of quarantine. Now things are reopening, and really justice was served, and I'm proud to be an American today, as we all should be. Elected officials, they're afraid to lose, and they're afraid to make the tough charging decisions. We saw it with Ahmaud Arbery down there in Georgia, where multiple county prosecutors chose not to bring charges until the Attorney General got involved. And a different situation here in Minnesota, but again, I can't give enough credit to Attorney General Ellison and the decision to charge Derek Chauvin, knowing how difficult it is. And hopefully, with verdicts like this, prosecutors will be more empowered to make the tough charging decisions, knowing that it's not easy to prosecute a police officer like someone with significant criminal history, but it's the right thing to do, and hopefully things change. And this one just felt so incredibly personal, like it was our own case, because it really was everyone's case. I mean, this was such an important trial because we all witnessed it firsthand, how Derek Chauvin, before our eyes, executed an innocent man over a $20 counterfeit bill. I mean, it was such an injustice. And to see it happen, and to see someone that we trusted, someone who was a law enforcement officer for many years, do this, and just the look on his face. And I really think the state said it best, where really this was just pride, ego, you know, an unwillingness to listen to bystanders who were powerless, you know, children, men and women. They saw this happening before their very eyes. I too felt powerless when I saw that video for the first time. And you know, to be on Law and Crime with you and to track this case every day from jury selection to verdict, and to hear the verdict be read on TV live with you, Linda, is a moment that I will never forget.
Neama, you say it so well with regard to what we are all feeling, but you and I have both been in a situation where we have tried defense cases. Now, what is going through Eric Nelson's mind right now, do you think? Just give us the tea leaves as a trained defense attorney who obviously poured his heart, whether we liked his client or not, gave him the best representation he could, but he has to go home tonight and his client is in jail for the second degree, the top count, the second degree murder.
Yeah, I commend Eric Nelson. He's an important part of our criminal justice system. He did his job and he did it admirably. It's a very tough case for the defense for the many reasons that we've discussed. So as he goes home today, he's probably going to lick his wounds and get ready for the appeal. Just like Mohammed Noor, their case is up on appeal the first time. An officer was convicted of murder in the state of Minnesota, that one just third degree. Eric Nelson does have a number of grounds for appeal, and I'm not saying they're going to be successful, but he's set up those appellate issues from day one, whether it's issues relating to the 2019 arrest, the third-degree murder charge, which we know has gone up, the change of venue, and those types of issues, there will be an appeal in this case, no question. And the other issue, of course, is sentencing. Sentencing is going to be about 8 weeks out after the pre-sentence interview is done. So he needs to prepare his case and make the best possible argument that he can to get his client, Derek Chauvin, something less than the maximum, which is 40 years in this case. So he has his work cut out for him over the next couple months.
Yeah, he certainly does. Neama, I have 2 questions for you on that.
Very challenging to find someone that's going to come testify that this use of force, which I've described as an execution, was reasonable. And I think Broad really stuck his neck out and lost a lot of credibility. George Floyd clearly was not a threat. There was no reason to exercise the force at the outset, much less when he's no longer responsive. And that's really one of the strongest arguments the state had. You know, those last several minutes where Floyd was no longer breathing and Chauvin continued to apply force to him. I don't think any reasonable person, much less an expert, could say use of force at the end of that 9-minute and 29-second period was reasonable.
So one of the things that's happening, obviously, as you know, Keith Ellison, the Attorney General, said he's on a commission, and we need to reform police, he said, so that this doesn't happen on their use of force. But we also have politicians get involved, including the person I voted for, President Joe Biden and Vice President Kamala Harris, who have apparently maybe asked for police reform and want to know if we can help. Do you think that Eric Nelson's going to incorporate the, I won't say interjection, but the commentary that's going on outside of politicians into his appeal? And could it help? Could it be a winner or what?
No question. He's going to incorporate the $27 million civil settlement. I mean, it's rare and uncommon for that to happen before a criminal case. It happened here and it happened in the middle of jury selection. So that's an issue he's going to raise. He's going to raise the Maxine Waters commentary, the Dante Wright shooting that happened about 10 miles away from the courthouse where Chauvin was being tried. So he's going to raise all these issues in appeal. I don't think it will be successful, but he just has to succeed on one. So just like he did with closing arguments, he's going to throw all those issues out there and hope that the Minnesota appellate court will just latch on to one of those appellate issues and send this back for a reday for an important part of American history. There's a reason why President Biden and Vice President Harris are involved, because today justice won. The American people won. This wasn't about black or white or law enforcement versus civilian. This was a day for all of us Americans, and I'm proud to be an American today.
Neama, I thank you again, obviously, for being with me in the coverage of this trial, and hope that you will come back when we're talking about the sentence. Yes, we had a guilty verdict. We had actually 3 guilty verdicts: murder in the 2nd degree, murder in the 3rd degree, and murder as an aggravated manslaughter against Derek Chauvin. Minnesota proved its case beyond a reasonable doubt. There's no doubt. Attorney General Keith Ellison said